The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain the Illinois divorce process. A divorce is initiated by filing a petition for dissolution of marriage with the appropriate circuit court, and then serving this along with a summons upon your spouse. The summons tells the other party where and when the first court date will be, as well as informing them that the divorce has been initiated. The other spouse will usually hire an attorney who will file an appearance, and then the case begins. Usually the first thing that happens is something we call the temporary relief phase. And this is where the court will enter orders basically setting a status quo for things like maintenance, child support, child custody, restraining orders if necessary, sometime payment by one spouse of the other spouse's attorney's fees. Basically enter temporary orders resolving these issues until the conclusion of the case and until a final divorce order can be entered. So this is not the final resolution of these issues, but it basically sets a status quo for how these issues will be handled until the divorce is concluded. And it allows people to receive maintenance, receive child support, allows the parties to determine how parenting time is going to be allocated until the divorce is concluded. After the divorce is concluded, a final order will be entered, setting these in stone. Shortly after the initial wave of temporary motions, and this can happen also at the same time, is the discovery phase of the divorce. And this is where basically the parties exchange information and disclose any marital and non-marital assets, income, and expenses, so that they can reach a settlement agreement or basically prove their case at trial as to how assets should be divided, how much maintenance should be allowed, how much child support should be allowed. The first thing the parties will do is exchange financial affidavits. These are forms, almost like tax forms, where the parties will list income, expenses, assets, debts, and other related information. So this is something that doesn't have to be done on request. It's just automatic. The parties have to exchange this information. But then each party can issue written discovery to the other side, and these are basically in the form of two things. Marital interrogatories, in which the party can ask the other side up to 30 questions in writing, and they can get court permission to answer more, and the other side has to fully respond in writing to those questions. And this helps flesh out agreements by giving the parties a full range of information in the other party's possession. The other part of written discovery is requests for production of documents. So if there are documents that might be in the other party's possession, the party issuing the discovery request can ask that all those documents or copies of all those documents be turned over to them. Ideally, at the conclusion of the discovery phase, both parties are sharing the same information and they have a full and complete picture of each other's financial situations, and they know what the other party knows. And this leads into the resolution phase of the divorce. So in the resolution phase, we're trying to achieve an equitable distribution of any assets, and that doesn't mean 50-50 split. That means basically whatever the court finds to be fair after examining a list of several factors, which we describe in a separate blog article and video, on a case-by-case basis. So the courts will use these factors to determine how assets should be divided. They will use basically statutory guidelines to determine how much child support should be granted and the duration and amount of any maintenance payments. Courts will also try to figure out how liabilities will be divided between the parties. Ideally, most of these issues will be resolved through a marital settlement agreement and a joint parenting agreement if there's children involved. These are basically just settlement agreements resolving these issues between the parties. If the parties aren't able to reach settlement agreements, then a trial will be held on each of the issues that the parties aren't able to settle outside of court. So what takes a long time sometimes in a divorce is, well, not only sometimes the discovery process can take a while, but also basically reaching these settlement agreements is where most of the work comes in a divorce, because trials can be expensive, so both sides' attorneys try to hammer out agreements as to asset division, spousal maintenance, child support, parenting time and responsibility, etc. Once those agreements are reached, or once a trial is concluded, the court will enter a final divorce order terminating the marriage and then laying out how all of those issues will be handled going forward. And at that point, any temporary orders that are entered in the temporary phase of the divorce are superseded by the final divorce decree. So thanks so much for listening. If you have any questions, please leave us a comment in our comment section. Feel free to call us for an initial consultation if you need help, 630-324-6666. Thanks so much.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.